Good afternoon. Thank you for being here and joining us. So I'm Mariah Bruce. I'm the Senior Manager of Workforce and Economic Development at Contra Costa College. And this is the Hiring Equity, Empowering Faculty and Staff to Support Formerly Incarcerated Students workshop. We are lucky today to have Sandra Johnson and Sabrina Rossetti from Legal Aid at Work, facilitating this workshop to support us in better supporting this population of students. So I will turn it over to our wonderful ladies here from Legal Aid at Work.
I also just want to say, because I'm very proud of this, I am also an adjunct faculty here at Contra Costa College, and I've been an adjunct faculty since 2004, and I teach in the real estate and business programs. So it's a pleasure to be home and also to be representing my organization that I work for during the day, my full-time job.
Okay, I'm Sandra Johnson. I am the Fair Chance organizer, and I am now the Racial Economic Justice Workers Advocate at Legal Aid at Work. I am also formerly incarcerated. I did about 15 years in and out. I relocated up here in 2007 from my hometown, which was Monterey. The last time I got out, I came straight from incarceration, a prison down in Chowchilla, up here to San Francisco, and I stayed at a program, Treasure Island, for about 18 months. This Fair Chance is really dear to me because I worked on it from doing it was Bandbox. I moved up to San Francisco. It took me a long time. I started looking for a job when that little box was on there on the application asking you about have you ever been convicted or I have a felony. And because it was very, very hard for me to get a job. So I filled out a lot of applications and eventually landed a job in San Francisco, a driving company, and worked there for about 6 years. The driving company worked there, it was a second chance job because they knew about my background because they used to come pick me up at the island when they needed someone to come in and work when someone didn't show up. And so I worked there about 6 years. The company changed hands, and instead of what I was told, instead of them grandfathering me in because they knew my work history, they knew my work ethics, they knew me, and I did a lot of things. I had worked when nobody else would come. I mean, I worked when on my days off. I worked when they needed someone that didn't show up to work. And I did a small commercial for them, and I also won Driver of the Year and Employee of the Month numerous of times. So I was a very good employee, and then to them too. And when they changed hands, they did another background check on me, and the company terminated me right away, just that 1 minute. And they kind of topsy-turvied me because I had just gotten came out of the program, just got my apartment, just got my little bucket, my little car, was coming to work every day, and had just separated from a relationship by myself, paying everything by myself, and they kind of pulled the rug out from under me. So I fell into an organization called Legal Services for Prisoners with Children, and they have a organization under them called All of Us Are None, and it's an organization of formerly incarcerated people. And they are an organization where they got together because we were being locked out of employment. So the first two things that you need when you come home is a job, and this is what the state of California lets you out and tell you. You have to get a job and you have to get a place to stay. However, you need employment for both those things, and so it was just kind of, it was kind of hard. I went and joined that organization, All of Us Are None, and they were working on, actually I volunteered at Legal Services for Prisons with Children, because when I got fired, I'll tell you a little bit more, when I got fired, I was just a little ashamed. I didn't know how to feel. I was kind of traumatized about being fired and just thrown away. So I went up to City College, and I said, okay, I'm gonna go back and I'm gonna get myself, better educated so that I can, in my mind, I thought I need to go and make myself more employable. However, through this organization, I found out nothing was wrong with me. I thought something was wrong with me. And so I started volunteering at LSPC, Legal Services for Prisons with Children. And they formed this fellowship, the Elder Freeman Policy Fellow. Elder Freeman was a freedom fighter. And I was their first Elder Freeman Policy Fellow. So they were working on Ban the Box. They had already did Ban the Box in San Francisco and the city and county, and they wanted to take it national. And so I wrote up for this fellowship. I wrote a little essay about how incarceration impacted my life, and it has impacted my life a lot. My brother just came out from doing 42 years. I've been incarcerated, and my sister had been incarcerated. So that essay won me the fellowship, and that's where I started working on the Fair Chance. I worked on the Fair Chance all the way through, because once I started telling my story about how I got fired because of my background, that was a story that the legislators in Sacramento, the lawmakers, needed to hear, because they were just doing their job. I learned, or I kind of thought they're doing their job, but they didn't know that they was actually impacting human beings. They were just making the laws. And so I went up there, and in 2018, I think it passed through the legislature. So I did all the testifying in each committee to help it get passed and turned into law. So how I got that legal aid at work was when I got terminated from the job. I didn't know that they had wrongfully terminated me or discriminated against me. I just was talking. So when I do these presentations with system impacted people, I always tell them, even if you don't know that you had done wrong, always call. We have an intake, and call and find out, because how I got here is I was a client, and they helped me with my case, and then 2.5 years ago, they hired me as their Fair Chance organizer. So that's what I do. I go around and I do these presentations for service providers, employers, and system impacted, my community that I come from. So that's a little bit about me. Stacy is our director of our program, and we both come from the Racial Economic Justice Program, and so that's why her picture's up there. So she did my paperwork. She was a fellow when they first took my case. Let's see, okay.
If you don't mind, we're gonna sit down as we
Yes.
go to the presentation.
So we're here to talk about employment for people with a criminal history.
Might have do the other one.
Oh, no.
Uh-oh.
Let's see if there. No, is that the next one?
Oops,
Oh, there it is. There
That's
it is,
next.
yeah. Maybe someone should control it. Okay, so normally when we do this presentation, we read this disclaimer because we want to make sure everybody know that this doesn't constitute as legal advice. So this disclaimer, just read right through it. The information provided during this training does not and is not intended to constitute legal advice. Instead, all information, contents, and materials are general information purpose only. If you have a situation for you to please consult an attorney for advice regarding your individual situation. And you can point them to legal aid at work. So let's see, is this gonna work? Oh. Okay, so if you don't, these are the three components to the Fair Chance Act that we're going to talk about. Ban the Box, fair chance process, and the off-limit information. And again, I mention all of us and none because we always pay honor to them because they are the first one that I know that worked on the fair chance, the Band-the-Box. So we always give honor to them. If we tag team, if you don't know, if you don't know what the box is, it comes on applications in numerous ways. They can ask you, have you ever been convicted of a felon? Have you ever been arrested? Employers figure out certain ways to ask. For example, they can say, is it anything that can prevent you from working here? They've learned, even though the fair chance was passed and it is a law, there's a few loopholes in it. And, it was gutted through the committees, and then employers have found out how to kind of ask little sneaky ways. Do you have a background? And so this is what it would look like. And they're not supposed to be on any applications now.
Also, they can, or they do, and they should not, but in advertisements,
Yes.
You'll find employers who still do not comply with the Fair Chance Act. And I like to use the example of Del Taco, which is a very large employer in the state of California and possibly throughout the country. But they repeatedly are offenders in their advertisements where they'll say, we do not hire anyone who has a conviction history or anyone who has been convicted of a crime or a felony or anything of that nature, which is a per se, an absolute on its face violation of the law. And so some of the work we do and some of the work that people who are being impacted do is identifying employers who are not in compliance with the law. We may reach out to them ourselves to bring that to their attention, or ourselves or other folks who see that may also contact the Civil Rights Department to notify them that there are employers out there who are violating the law. Yes?
I think, so when you say most employers, is there like a specific industry that is allowed?
Oh, thank you. Should I repeat myself?
That's a great question. Thank you for asking it. Yes.
So that is a very good question. There are certain industries that either have a mandate under state or federal law, which would allow them to ask about your conviction history outside of the mechanics of the Fair Chance Act, meaning the timing that normally would be required, and we'll be talking about that in a little while. And then there are employers who, in addition, can act outside of the timeline, but also depending upon what the conviction is, and it's very specific. There are some convictions that would not allow you to work in certain jobs or industries. But since we're on this point, they're not absolute rules. So what I mean by that is that an employer who might have the right to ask about a conviction history at the beginning of the process instead of waiting until they make a conditional offer is not then allowed to blanketly deny you a job just because they have an exemption from following the timeline mechanics. It's still not allowed for them to do a blanket ban, which means I don't care what the conviction says, you have one, and therefore we don't have to hire you. They still have to comply with the rest of the mandates of the Fair Chance Act, doing an individualized assessment and not simply saying, well, you got a conviction history and therefore you can't work here. And prior to amendments to the regulations that interpret the Fair Chance Act, that's what a lot of employers were doing. They were saying, oh, well, we have an exemption from the Fair Chance Act, which was really the mechanics of when you can ask about a conviction history. You have the right to ask up front, but it doesn't mean that that you have the right to discriminate against everyone with a conviction history because you don't have to follow the timeline of the mechanics. So that was clarified. And so unless there is an additional provision which identifies very specific jobs, that automatically you cannot work and have that particular conviction. I'll give an example of some financial institutions. If you want to work in a bank, there are some convictions, but not all, and not even all convictions that might relate to theft. And that's been some changes to that law based on a recognition that we're leaving behind very qualified folks who could be working in this industry by holding against them any kind of conviction whatsoever, no matter how small or petty. So there have been some changes at the federal level to recognize that some convictions can be waived. Also, if someone has had a dismissal of convictions, that also should not be used in the evaluation. But aside from having both the right to act outside of the framework of in terms of the timeline, you actually would have to have a specific conviction that is specified, and that person needs to have that before you could just say no. Otherwise, you still need to go through the individualized assessment. Mm-hmm. Yes.
If someone has pled like no contest, would they still have to reveal the nature of that particular proceeding?
So no contest is like, I'm not saying that I'm guilty or I'm not, but in most instances, you would still be ending up with the conviction. So what you pled wouldn't be the defining or determining factor. It would be what was actually the disposition of the case. So they would need to identify, or it would show up. I don't say they need to identify, but it would show up what the ultimate disposition was.
So this is the fair chance process, and I'll let her explain because she goes through it so much better.
So this is the timeline that we were mentioning, and this is the mechanics of what the Fair Chance Act essentially provides to people, which in a nutshell is the opportunity to be considered for the value that you bring without your conviction standing in the way of someone even seeing you as a potential candidate. And so what it basically requires is that an employer treat you like any other candidate while they are evaluating you. So they cannot ask you any questions about any conviction history, and they cannot review anything related to a conviction history during the process of interviewing you, considering your application, and then after considering you with no knowledge of whether or not you have a conviction history, if they decide that you are in fact qualified for this job and they would like to give you the job, then they would make a conditional job offer to you. And this is no different than what would happen with someone who doesn't have a conviction history. So you're getting a brand new job, you start here at Contra Costa College, and they offer you the job and whatever the terms are. And almost all employers will say it's conditioned upon a satisfactory, background check or a satisfactory, completion of the employment process for them. So at that point, that's when an employer, if they choose to do so, can run a background check, which can include any information about your criminal conviction. And I'm going to deviate for just a moment and make this very important point that we are trying to, from an education standpoint, make sure that everyone knows. In the absence of a mandate that we just talked about from a state or federal law that says you have to conduct this background check to make sure that this person is not allowed to work here, background checks are not required. Employers, either through just practice or sort of this lazy perception that if I run a background check, that means I'm creating a safe work environment. So I've sort of checked the box. But there are two reasons why that is really not true. And they're both related. One is we're talking about today, very few people with conviction histories are in the workplace at every level. And the last time I checked, people keep doing stuff they're not supposed to be doing in the workplace, and many of them do not have conviction histories. So just simply relying on this kind of scapegoaty sort of way of suggesting that you're creating safety, which is not comprehensive. You really need to have policies that cover everyone, irrespective of whether or not they have a conviction history, because those policies will keep everyone safe. And again, like I said, because the vast majority of people who have conviction histories are not in the workplace and they're not doing these things, that until you do it, there's not a problem. And so we just want to make sure that people understand that doing criminal conviction background checks are not required, and to do so without anything more does not really create a safer work environment. All right, so coming back to the mechanics now, so you've been offered a job, and they've made the statement that it'll be conditioned upon a satisfactory background check. At that point, before they run your background, and this is true for anyone, they do need your permission. So they would either get it through, onboarding that's electronic nowadays. You just check a box saying, yes, I give you permission to run my background check. And we do want to make sure that folks ask for a copy. So there's also a place to say, I would like to have a copy of the background check. That becomes important if the employer then decides that they may want to rescind the job offer. So you give them permission to run the background check, they get it back, and they review it and see. For a lot of employers, it's like, it doesn't matter what it says. You have any kind of conviction history, the knee-jerk reaction is, we don't want you to work here, so we're going to take the offer back. So at that point, the employer will make a initial adverse decision, and that is that they must or should, they must, and they should be in compliance with the rules, and that is that they need to give you a written notice of the intention to rescind the job offer. They need to identify the specific conviction that they are using as a basis for why they want to rescind the job offer. And just to drill down a little bit more on why that is important is because the law requires that, and this is to stop people from doing blanket denials just because you have a conviction history. There needs to be a relationship between the job duties in question and the person's conviction history. And that relationship needs to establish that it can be an adverse situation to have that specific individual in the job. So for example, did you want to give the example I always give about
the example is, say you are applying for a concierge in a hotel, and you're just standing there, your concierge, they either carry the luggage or they show people around, and this person has a DUI in his background. That DUI has nothing to do, they're not doing any driving, that DUI has nothing to do with being the job that you're going to be doing in that hotel, which is non-driving, just showing people to their rooms. So that is not a nexus to the job. However, I'm gonna give you I never talk about this, but my job was a driving job. I would drive people to dialysis and elderly people in a vulnerable population. I've never had no DUIs, I never had no reckless driving, and I never had no elder abuse or any kind of case with a vulnerable population. So that's another reason why my job driving people, picking them up at their house, driving them, had no nexus to the work that I was doing. So that's another example.
So the two parts are that it's directly related. What your conviction was is directly related to the job that you are seeking, and that the conviction itself, having you do that job, would adversely affect your ability to do the job. So if the job was a driving job and you have 2 or 3 DUIs and they are relatively recent, there would be a very strong argument for the conviction having a direct and adverse relationship to the work that you would be doing. But in most instances, there's no relationship whatsoever, and the mere fact that you have a conviction history is the basis for employers to say no, which amounts to a blanket ban, like you are just, you're not worthy to work at all for no other reason than you have a conviction history, which is really inconsistent with our expectations of people when they get out of prison. We expect you, we demand that you come back and you be a lawful and abiding, law-abiding citizen. You get a job and you contribute to society, and then we lock you out on that same basis. So it's really unfortunately an ongoing, and I know for people who are actually experiencing it, it feels like a never-ending battle just
Very
to
frustrating.
have the right to do what they are ready, willing, and able to do. And that's in part to contribute to society, but also to be able to take care of themselves and their responsibilities, and to stop the, the revolving door back to prison. All right, I'm going to hurry up now. So now the employer has said no, or at least preliminarily, that we'd like to take the job back. They've identified the specific conviction that they think is directly and adversely related, and they have notified you of their intention to take the job back and provided you with up to 5 business days if you wish to contest their decision. There are different reasons for contesting their decision, and there are specific things you can do. So I'll just start with one, and then Sandra, you can take the other two. One is that there is an error on your background check, which happens quite frequently. Actually, you can go ahead, and then you can talk about the other two as well.
Yeah. So if there's an error, or if there's a dismiss, if you get your record clean and there's a dismissal on your record, they're not supposed to consider that, or they're not supposed to consider a dismissal, a pardon, or they're not supposed to consider your juvenile record. They're not supposed to a pardon or a certificate of rehabilitation. There's certain things that they're not supposed. Oh, wait a minute, we're talking about the errors.
Yeah.
I'll tell you on mine, on my DOJ, it had, my last name is Johnson. That's a common name. And it was a lot of errors on my background with dates that, what do they call them, fractions or convictions that was not me. And I had to prove it. I had to go and I had to show that I was incarcerated during this time. Maybe someone used my name. My birthday was wrong. Maybe someone else had my birthday, their last name Johnson. So there's always a lot of errors on a background. So that's one of the reasons that we always advise everybody to make sure that you get a copy of your background so you can see what the employer is talking about.
Mm-hmm. Also, sometimes people, I think he might have left his water bottle. Sometimes people will presume that because the employer did not identify the specific conviction, which they are required to do.
Yes.
So if the employer raises a flag and you don't know what they're looking at, you might start disclosing things that they're not looking at, that are not actually on your background check, have been dismissed. And so that's another reason why we really want to make sure that people get a copy of the background check that the employer is using, so they can speak very specifically to what the employer may be addressing, but the employer does have a legal obligation to identify what the specific conviction is that they believe is directly and adversely related to your ability to perform the duties of the job.
And I just want to add, and if you are working with a person or working with a population that does have a criminal background, I always, when I do my presentations, I always tell them, if you're in the job hunt mode or you're looking for a job, before, if you have an opportunity to get a record cleaning or a clean slate, go to a clean slate program, to do that ahead of time so that you can get some of this stuff removed off your background, and that way it'll show up as dismissal. I hate that it shows up that way. And then they cannot, it is against the law for them to ask you about a dismissal, you know.
Or to use it as part of the decision making. So the first one was errors on your background check, and then, so that's one thing you can speak to, and then the other two things that you can speak to are mitigating circumstances and rehabilitation.
Yes, okay.
Do you want to say anything about that?
So, no.
Okay, so one clarification that was made after I mentioned that there were some regulations that were clarified in October of 2023 by the Civil Rights Department. You do not have to provide evidence of mitigation or any evidence of rehabilitation. It's optional. And in part, someone might not want to do that if they've been doing the job for 6 years. They have an excellent record. Why do I have to keep coming back and begging and proving to you, keep returning to this conviction when I've been doing the job? I've done the job excellently. Clearly, my conviction has had no relationship directly or adversely to the work. And so what the regulations clarified and wanted to do was allow people to let their record of what they're doing in this world today speak for them, and not to force them to continue to have to go back and rehash something that really shouldn't be an issue based on 6 years of being the employee of the year, employee of the month. And so that's why there was a change. But it is optional if someone wants to provide evidence of rehabilitation or mitigation. But if there are errors on their background check, then they have up to 5 business days to provide the employer with a clarification, which should be done in writing, because of course the employer could say, well, we never got it, or you never said X, Y, and Z. And if they decide to clarify about errors, they can ask for an additional 5 business days. So they can get a total of 10 business days if there are actually errors on the background check to provide the employer with a clarification if they wish to provide any documentation. Another clarification from the regulations is the employer cannot keep coming back asking you for more information. So they can't be like, okay, we'd like to see a copy of your probation report, or we'd like to see the police reports, or we'd like to see. The employer cannot ask you for any specific information. Whatever the person provides in addition to what the law provides is what the employer needs to do a reconsideration or reevaluation. So we're almost at the end. So after the employer has initially notified you of the intention or desire to rescind, and you have decided to respond, you can respond with corrections, you can respond with mitigating circumstances and or rehabilitation if you would like to. Then the employer is required to reevaluate with all of this information and then make a decision. There are times when employers will decide, we are satisfied and we will give you the job, but not enough of the times. So very often, again, like I said, this knee-jerk reaction, which is lazy, and it so often doesn't even consider any of the factors other than you have a conviction history. Many employers will go ahead and make a final determination not to give the person the job. If they do that, there are several requirements that the law asks of them. Number one, you must do that in writing. What we find so many times is employers, once they ask you about the conviction history and you either do provide information to them or you try to, they ghost you. They don't call the person back. They don't respond to any of their emails. They just disappear and never, move forward with even just the courtesy of notifying the person what they've decided to do. Other times they'll say verbally, "I'm sorry, we've decided that we're not going to fill the position right now," or it's on hold. I mean, so many different ways of sort of getting out of actually making a formal determination. And so they are required to notify you in writing of what their decision is. They're also required to let you know if they have any internal process where you may appeal that decision. And then they are required to notify the individual that if they believe that the employer's decision was wrongful, they legally denied them the job or discriminated against them, then they have to notify you of the right to file a complaint with the Civil Rights Department. And if they didn't give you a copy of the background check at the pre-adverse stage, or when you check the box, they also need to give you a copy of the background check that they are relying on.
And that's a very important point, this last one, the written notification and everything that she said, because a lot of people with background don't know this. They don't know their rights. That's why it's really important for service providers and people that are system impacted to know this information. That's why we do this, because a lot of times they don't know. People are just looking for a job. When they get out, they're trying to get away from incarceration. They're trying to just get their life back on track, provide for their families. They don't have time to think about all this stuff. So that's why we do this this presentation, so that we can inform, educate people, and then you guys can educate the population that you work with. So the last part is off-limit information. So the off-limit information, I think that employers cannot ask you or use, like she said, anything. First one is an arrest that didn't result in a conviction. So that is if you haven't been to court and hadn't got sentenced. However, the only exception is that can consider an open case. And an open case is if you're still going to court. If you've gotten if you've been charged and you're still going to court, they can consider that as that's one of the things that they can consider. They cannot consider any pretrial or diverse programs. That means a drug court. That means if you've been through any programs, if you went through a program instead of jail, they cannot consider that. They cannot consider any judicial dismissal, convictions, or a certificate of rehabilitation. I never say that word right. I just don't say it right. And they cannot consider a certificate of rehabilitation. And a certificate of rehabilitation, a person can get to that, and I always advise when I'm talking to the impacted people, start your record cleaning, because you can get up to that certificate of rehabilitation, because I've gotten my certificate of rehabilitation, and right now my application is in the governor's office for a pardon. He hasn't signed it, but it's there waiting for him. So record cleaning, when I tell them, when they're like, well, it does take a little while, it takes a little work and stuff, but it's so much worth it, especially if you want to get this stuff, if you want to clean up off some of this stuff, and it's also to get a better job. So they cannot consider any juvenile history at all. They cannot consider any marijuana convictions more than 2 years old, and in San Francisco it's more than 7 years old, unless you are applying for a job to supervise minors. So, yeah.
What's your question?
Is that working? Hello? Yes. I was actually really curious about, I've never heard of the certificate of rehabilitation. So is that, so you go through like a program and you get a certificate, and that goes to the governor's office and they issue a pardon? Is that how that works?
The certificate of rehabilitation is after it's For me, the certificate of rehabilitation was more important because it said to the state of California that I was rehabilitated. The certificate automatically puts you in an application in for you. Once you get the certificate of it's an automatic application for a pardon. I'm not really interested, and I'm being honest about a pardon because, you know, and then my certificate of rehabilitation just told the state of California that I have completed these steps to be considered as rehabilitated. But however, I know I'm rehabilitated. California don't have to tell me nothing because I know I've done my work. Yeah.
Oh, that's cool.
See, so navigating the fair chance process, that's what we're going to talk about now. Oh, go ahead.
I have a question here from Zoom. 2 questions. What is the recidivism rate of all formerly incarcerated people in California prisons? And
So it actually is not a blanket rate because there are different types of incarceration. There are people who get incarcerated for very short periods of time, and we know that without support, when they leave prison, that they do come back to prison. We also know that people who were incarcerated for very long periods of time, and I want to snap out of the presumption, that's why their recidivism rate is very low. So I'm going to add a couple things about that. People who have been incarcerated in state prison for a very long time have not only requirements to get out of prison, but they actually do have a lot of systems within prison to assist them if they are actually interested in changing. And people are, because it's one of the requirements to get out of prison, but it's also one of the ways that they can ensure that they will be successful. So that's where you find people who are actually getting drug treatment, where they're not getting it in the situations where they have the shorter sentences. There are no resources really there for them. So folks who have been incarcerated for longer periods of time, they're getting the rehabilitation around drug treatment. They're also getting trades. If they are interested, they're getting educations. If they're interested and able, and usually that's not a suggestion that we need to lock people up for long times so they can do that, but that is something that is happening along with a longer sentence when they are incarcerated. And I do not know the rate right off the top of my head. You can look it up, but specifically for people who have been incarcerated for long-term periods, they have a very, very low recidivism rate, and they almost never commit the same crimes that sent them to prison. If they do commit something, it's more of, like we were talking about, more of a poverty-based situation. So it's not a blanket thing, and I don't mean to be preaching to the person, but I just want them to understand that the populations are very different and they end up in prison for different reasons. Also, right now, we don't have a meaningful way of dealing with people who have mental health issues, and we incarcerate them. And so there are no real services. There's nothing for them when they get out. And so because we have such varying populations, it would really be inappropriate to believe that there is this blanket number that would not only quantify, but meaningfully evaluate like what happens for folks when they're inside, and then as a result of that, how does it prepare them and or help them? All of those things are very good, but the problem is, when they've gotten the drug treatment, I've had clients, and I didn't talk about my background before I came to work for Legal Aid at Work, but for 13 years prior to that, I did something called parole defense. So I helped people who were in state prison to go before the California Board of Parole hearings and to establish that they were ready for release and then have the opportunity to get out of prison. And the majority of my clients had been in prison for at least 20 years. The longest was 46 years prior to having the opportunity to go before the parole board. And during that 13 years, I helped about 135 men and women get out of prison, and none of my clients returned to prison for any significant sentences. Some of them got some parole violations and they had to go to jail for a shorter amount of time, but none of them returned to prison with any kind of convictions that were related to what brought them to prison. And so I say that to say what the problem is they get out of prison with more educations. I'm from West Oakland, and some of my clients I grew up with. Over the course of the time that I was doing the work. One of my clients, my mom was his teacher, and so what I found in knowing them prior to going to prison, a few of them, and then when they got out, that some of them were coming home with better skill sets than folks who never went to prison, because they got their education while they were incarcerated. They took advantage of all of the opportunities there. They leave them with 4 and 5 trades, and so while they're in prison, there is no problem letting them be landscapers, letting them build stuff, but when they get out, they can master trades. They get out, they can't get a job. And so so that's where the stopgap is, and that is part of what sends people back to prison, is that they're not being given meaningful opportunities when they're not being, in some respects, when they're not being, I don't want to say taken advantage of, but when the benefits versus the burdens are not, in their favor, then we can use them to be firefighters and everything else, and they can risk their life for $1 or $1.50 a day for the same things, and then when they get out, we don't see a value in allowing them to do the very same thing. So it's kind of clear what side we're on, but I just want to kind of broaden some of what are the finer points behind some of that. So.
And I'll talk about the short term. When you have, if you go to prison with a shorter sentence, there's no programs in there. It's just basically you're being warehoused, you're being kept there, you're working the institution, you're doing actually.
For free.
Yeah, you're actually doing, I know for me, what I say is incarcerated people run the prison. They make the prison run. They function. They do all the work from the warden's office all the way down to, like she said, landscaping. And the COs just stand over you. So a lot of times they're working and not having any kind of classes, NA classes, parenting classes. None of that stuff is happening inside, except if you're a long-termer. When you're a long-termer, you have a little bit more access to certain programs because you have to do those programs in order to prepare to leave. So they prioritize the long-termers. Yeah. So the second question. Mm-hmm.
Yeah, the other question is, what is the recidivism rate of all formerly incarcerated people who have completed the Clean Slate program?
Again.
And I'm not completely sure that anyone keeps those statistics, because the Clean Slate program is not like a program that has something to do with your rehabilitation or resources that are going to be provided to you. What it's about is under the law, are there, and their conditions, I'll give you an example. So for a lot of people, they have to have 10 years after their last conviction of not having anything or having done anything. That's them. That's not a program. They've made that commitment and they did the work for 10 years of changing their life. So that's one of the requirements to be able to participate in get your record cleaning, and that's mechanics. So that's lawyers filling out paperwork that then goes to the court, and then if you've satisfied the requirements, and that's where your mitigating circumstances and rehabilitation can also come into play, then you will be granted a dismissal of your conviction. And so the person is asking the question may know this, but I just want to make sure that other people understand that saying that you're going through a Clean Slate program is not an actual program that provides you with like resources to get your life together. You've done that work on your own before you come to the program to help you with the legal documentation that can dismiss certain charges once you've demonstrated that there's not going to be any problems for 10 years. So that's why there's no real tie to the clean slate dismissal or expungements and then someone's recidivism back into prison. It would be things like the other stuff we're talking about, which is after doing all that and then going to school and, even people who come out and then go to school, and we have a few clients that we've helped, and then they still can't get a job. That's a more significant tie to recidivism. And so I know we sound like a broken record, and some people would say we sound like bleeding heart liberals. But what we're really doing is pulling back the veil on these concepts and these like buzzwords that we're using that really don't, as Sandra said, really look at the human toll and what it really is happening for folks.
So on this slide, is that good? On this slide is the copy of Know Your Rights. I think I've got some books. Yeah. So this is just where it shows where you can get your record, how you can get your background, how you can get live scan. So this is one of the toolkits that my organization created, and this says 2020, but you guys have a new version of it because Sabina updated the whole thing. So it's
so where this might be relevant and helpful is we've talked about getting a copy of your background check so you know what's on there. But sometimes you might need to go all the way to your actual conviction records, which is referred to as a DOJ rap sheet. And so in order to obtain your DOJ rap sheet, because background check companies use different sources to fill out or to complete the background check. And a lot of times they use court records. They don't use your DOJ rap sheet. And court records can at times not be properly updated. So there may be things that are showing up in the court records that really shouldn't be, and they're not on your DOJ rap sheet, or they are on your DOJ rap sheet, but they're on your DOJ rap sheet correctly. And then thirdly, your DOJ rap sheet is wrong, even though the court records have been updated. Yeah. So to go to the source document, this is clarifying how that can be done, and you have to do a live scan, so you do have to do a fingerprinting process to be able to actually get the DOJ rap sheet from the Department of Justice.
And today there's a lot of different organizations that doing clean slate, that is doing the live scan for free. So go ahead.
Are you saying there is no state agency or CBO program that tracks people who have gone through the Clean Slate program to look at its effectiveness?
So, no, we're not saying that, but maybe not in the way this person is asking. Like, is there a direct tie between did you get your conviction expunged? Because that's what clean slate programs do. They help you with expungements and if you return to prison. So there are all these things in between this, and I think that's what we're trying to say. There's not just like a direct relationship between an expungement or a dismissal and you returning to prison. Sometimes it is related then to, are you being given opportunities for employment? But sometimes there are other things that can come into the individual situation which could lead them back to prison. And so I don't think that there's research that makes this direct tie between the two, because often there's something else in between it, if that makes sense. But it's certainly something that could exist. We are not aware of it. You might be able to check with some other organizations, NELP, the National Employment Law Project, to see if they may have data. The DOJ keeps probably some of the most comprehensive data on subjects around recidivism. You could go and just put into the internet search, recidivism after expungement. And so saying clean slate is just a phrase. it's a catchphrase, because essentially what it is it's after a dismissal or expungement, and see what might come up. But to the best of my knowledge, there's not a suggested direct relationship, because I can't really see how there is when there's probably something else in between. But it's certainly something that hopefully if you are interested, you could look and see what might be out there.
Okay, this slide right here, when we talk about, there's two different, we're talking about two different things. A lot of people say background checks, but there's also a rap sheet. A rap sheet, there's two different versions of a background. One is a rap sheet, and that is an official government record. They can see every time on a rap sheet, what comes up is every time you've been in court, every time you've had any kind of contact with the police. It has criminal information only on it, and it's generally confidential. Only courts and law enforcement can see that. So if you are applying to, like, we had a client that was applying, wanted to be a police officer, that they did a rap sheet, they did a background check on him, and they got his rap sheet, and that's how they seen the law enforcement seen that he had a background. A background is just basically, most like she said, private fingerprint companies do. It contains limited information, limited criminal information on it. It also includes other information like if you've been evicted, if you, private landlords can see it, banks can see it, and sometimes your credit reports on this background, your credit report, but everything from your past, but not everything from your past has been reported on a background check.
So a minute ago, she said, like private fingerprinting, what we mean is, like background check companies like Checkers.
Yeah.
I think a lot of people are familiar with them. So that's kind of fee-based, where they will run a background check usually for an employer. Some will do so when you are trying to rent housing. Some other ones as well, I think, for credit. And they generally do include criminal conviction information, but they don't have to ask for that. Because remember, background checks are not required to provide criminal, or even to seek out criminal conviction history. And there are employers who don't run criminal conviction background checks. Yes, my dear.
A lot of the policemen, you know, when it comes out after all of these activities, that they have been, they've had convictions and problems in other positions, but they still go from police department to police department. And I'm just wondering, do they just make a judgment call, or they can do what they want? I mean,
apparently, I mean, we'd love to pull back the veil and understand why the people that, because we're talking about not trusting people with sensitive populations or vulnerable populations, and yet we have a whole nother sort of silo for, and they have a lot of protection laws which shield their records from being able to be disclosed to the public. Now, internally for government law enforcement, the courts, they see those records. And it's, you know, we've never brought this up. This is a great argument for why, you know, background checks, you know, it's sort of not fair that they're used against certain populations when we have really sensitive, where you really are in sensitive jobs, where, and yet, you know, background checks often are maybe not even ran, or they're certainly not considered. So, and we don't seem to have a problem with that when it comes to law enforcement. I mean, some of us do, but by and large, no one's raising that, and that's a really good point. And it just goes to what we're saying, ultimately, that employers have discretion. Where this is weird is, law enforcement does have a mandate to do those background checks and to do that assessment that we're sort of talking about that doesn't even come from the Fair Chance Act. It's a practical one. Is this background issue likely to create a problem with the duties of the work, and yet they seem to very often determine that the answer is no if the person has already been working in law enforcement. If the person has not already been working in law enforcement and they want to work in law enforcement, and I won't do a drill down on who those people could often be, but the bottom line is that there is a tremendous amount of individualized discretion being used, and being used in the favor of folks who are currently, even when there are some legitimate questions that should be raised. Certainly there are police departments and law enforcement who will look at things and decide, this, you can go somewhere else, but we don't want you here. But that was really an excellent both assessment as well as question. Thank you.
So I have a question. How can an applicant with the record know that they were denied employment because of their record without the employer directly saying, well, they judged them in their own mind?
That's a great question.
It sure is.
It sure is a great question.
And I'll go by analogy and say, in some respects, very similarly to when people who are members of protected classes, whether it be someone who is a member of a minority group, someone who has a different sexual orientation, someone who has a disability, really, ultimately, it is very difficult to prove unless the employer says, I don't want you to work here because you are. Now, the strange thing is that there are a large number of employers who will have the audacity to say that.
Yep.
So we were looking at a situation with a woman who was pregnant and had a leave, and then she was going to come back to work a certain day, and her doctor extended her leave, and or she had a child care issue, I can't remember, but the employer literally said, well, we're going to go ahead and let you go now because we foresee your pregnancy is going to be an issue, or your child care is going to be an issue. So there are plenty of employers who will open their mouth and tell you, we don't want you to work here because of protected classes. But in the absence of that, which is also very often the case, it really becomes a facts and circumstances analysis where you look at the totality of the circumstances, and there is often some evidence, whether it's emails or texts or behavior in the workplace. And so one of the pieces of advice, and when we get to it, we can skip it here and we're just about done, is when there are issues that come up, you go to an interview and the employer asks you a question they're not supposed to ask verbally, then we ask people to document it, document as much as possible the time, who the person was, what they said, as much as you can. If you're doing an application and it's in the portal of an employer, which you may not be able to open later, and you see that they're asking an permissible question, we tell people to take pictures, print things, get a screenshot, but to try and keep that documentation, because at most of the time, it's going to end up being sort of your perspective versus their perspective. And that's why many people don't win their cases, even when there may not be a question as to whether or not it really happened, but it's what can you prove. So, very hard.
So it's really good to keep documents.
Yeah.
And today, a lot of applications is online. And so make sure that they, once you apply for that job online, and you have some red flags, start taking pictures of it, because if they deny you, they'll lock you out of that application. You will never be able to reopen it again. So it's really important, if you're applying online, to make sure that you get that you keep records and take screenshots and print out stuff from that.
And don't save the PDF that they sent you, because a lot of times you won't be able to open it later. Because they're system protected.
Yeah.
Now, I know we are actually we're running past our time. Oh, no, we still have, okay.
30 minutes.
All right,
Okay.
okay.
We have until 3:30, including
Okay, all right,
So, so this right here is also in the book. It's just little tips on how to, do a personal statement. A lot of people don't know how to do a personal statement. We also have a letter, when you're writing a personal statement, also talk about your accomplishments, what you've done, what you're doing inside, what you've done inside and out, what other education that you've had. Always, when you're writing a personal statement, say what, always take accountability, don't blame it on anyone else, but also talk about what this situation taught you. Be sure to share the values and with the company, your relevant skills. Tell them why I'm a good candidate. I did a personal statement, and I got help from mine years ago, but that was a recommendation, and this is in the book, so you'll be able to show your clients. Also, we also have online on our website, we have a link with this toolkit on it, so you can share it out to people too. This is actually a real client's letter. You can see where she writes when she was 18, she struggled with drug addiction. She got convicted. She spent some time in prison. She took full responsibility of her actions. She came home. She went in a drug treatment program for 18 months. I always, when I see 18 months, that's how long I stayed, but this is not my letter. She completed the program, and she's staying with she's been free of drugs for years now. She also is telling what she did. She obtained her high school diploma. She volunteers with the organization, and she mentors kids with risk factors for substance abuse. So that's a letter, like previous one, that's a letter how this person wrote it. She talked about the past, she talked about what happened and what she's doing now.
and we do want to just clarify that providing evidence of mitigation and/or rehabilitation is optional. You do not have to provide that. It is an additional thing should you desire to do so, but it is an option for people.
And when we talked about, these are just some pictures of what you could submit for rehabilitation. You could submit if you went to college, if you got your GED, if you're doing any kind of volunteering. People from, you could get letters of, you could get character letters written. There's a template in the book that if you run across someone that you want to write a reference letter for, a character letter for you, and they don't know how, there's a template. You can go to that template and just fill it in, give it to that person, they could fill it in. But these are just some of the pictures. And this is the template that I'm talking about, the support letter. It's also in the book that a person can follow, because a lot of times you can get a character letter or support letter from just about anybody. You can also get a support letter from someone that knew you from before, and they can put in, hey, I knew this person before. Today, this person is this person. I see the change in them. So this is a page in the book that you can just use to get that support letter or have someone write the support letter. So we do know that these common violations are still happening. We still do know that they're asking about, that's why we do these presentations also, because these violations are still happening. People are still asking about your conviction history on a job application. They are still doing a background check before a conditional offer. We know that. We know that in advertisements, they're stating no felon, no convictions in the last 7 years. We do know that that is still in a job announcement. We do know that they're considering off-limit information, which is dismissals, any kind of your juvenile record. We know that they're still considering that off-limit information. We know that they're doing the wrong process, like they're ghosting you, they're not giving you your copy of your background, they're not giving you a letter, they're not following the fair chance process. We do know that they're not, like I say, not giving you backgrounds. We know that employers are not giving you the 5 days to respond. We do know that. And of course, we know that the blanket statement is like, we're not hiring nobody with a felony record. We do know that these violations are still happening. She
We
was
sort of
talking,
talked about this just in terms of how to be able to start the process of defending your, what happened to you, and being able to establish how the what's, when, how and where. And right now we have a client that we filed a Fair Chance Act suit for, and this woman is phenomenally amazing because she has every call, record, every document going all the way back to 2018 about the systematic denial of opportunities for her because she has a conviction history, and in a similar fashion to Sandra, was previously working in this, in the oil refinery industry, and doing a very good job, making a good living. And then many of the oil refineries started to join these, what they call consortiums, which are like programs, to have specific companies do their background checks. And those companies didn't merely go and get the records and then provide it to the employer for the employer to do the evaluation. They decided that they were going to qualitatively evaluate someone's record. So they started with a score of 0 up to 7, 0 being no conviction history, 7 being someone who is on the terror watch list. And then they seem to arbitrarily put together convictions that have no relationships from the number of 1 through 6, and then report them to the employer. By the nature of you scoring people higher based on their conviction, you're sending a message to the employer, you don't want to hire anybody with higher than X, Y, and Z. And then they allowed the actual owners of the refineries to give them a maximum score as to who can come and work in their refineries, and many of the refinery owners chose a 2. So for basically anyone who had anything close to or actually a felony were systematically pushed out of the industry and the ability to earn a living and to work there for no other reason than they had a conviction history. It's not directly or adversely related to the job because, woohoo, you were already doing it and doing it successfully. So we are in the process of challenging that as a blanket ban, essentially, against people who have any serious conviction histories. And fingers crossed.
yeah, and this is just, again, how she said that you should document it.
And we have all of this from her, everything. Her notes would say who she talked to, what time it was, what was the phone number, what did the person say to her, what did they tell her to do next. So, and just because she kept those level of records, her case is 10 times stronger, and we think that we might be able to change an entire industry and their practices because she was very, very, very careful about her records.
Do you ever work with like the ACLU and partner with them on like lawsuits and things like that?
We do. Where we do more often is we, along with the ACLU and other partners, we will provide something called amici briefs. So there may be a suit before, let's say, the California Supreme Court, and I have an example of one where we provided an amici, and we were actually allowed, so when you do oral arguments before the court, they'll give you 30 minutes, and the plaintiff's counsel allowed our organization to have half of that time. So we were able to argue a case of very significance, and I'll tell you about that in just one second. But that's where it shows up most often, where we are partnering with other like-minded organizations. We also do legislative and policy advocacy. So we work with the ACLU and other organizations on legislation. We have been working on the Fair Chance Act and we have been able to make some inroads. In our dreams, we would like the Fair Chance Act to say that background checks cannot be ran unless there is a state or federal mandate that you do so. And if we can't get that, and so far we haven't been able to, then the employer needs to demonstrate a business necessity for running a background check against someone that they're not required to do it, because we all have privacy interests in our personal data, whether it be medical records, but we also have a privacy interest in our background check. That's why they have to get your permission before they can run it. It's somewhat coercive if you say, give me the right to do your background check, I don't give it to you, and then you don't give me a job. That's really not permissive. So to answer your question, there are like a lot of different ways that we partner, and then sometimes when we actually do our own lawsuits, like we are doing for the woman that I mentioned, we may partner with an organization, and we may both be counsel for that plaintiff. So, and I hope because I said I was going to say something, and then I hope I answered the question.
Okay, you want to give that example? The Supreme Court.
Oh, yes, that's what I was trying to remember.
We are developing material to educate people about this situation too.
So this case where we were given half the time to make the oral argument, and our program director actually argued before the California Supreme Court, the facts were a woman who was working for the San Francisco District Attorney's office. She was a Black woman who was at work and talking to a coworker who told her that she felt she was a scary N-word.
Which she worked with her for many years.
Yeah, they had, at one time, she thought they, I guess, were friends or had a sort of a friendly relationship. But yeah, she told her that that she thought she was a scary N-word. And essentially the question before the court was, can one incident of racial animus, harassment, or discrimination by a coworker rise to the level that is sufficient to find a violation of Title VII, or at the state level here in California, FEHA, which is essentially covers the same categories of protected classes, race, sex, et cetera, as Title VII, but is more inclusive. We have a few more. And though the court ultimately did say that a facts and circumstances analysis, again, going to why it's so important to keep all of your records to provide the full context, because that's where cases are won or lost, is a full context in the absence of an employer saying, yeah, I just don't want your scary N-word to be here. And another wrinkle was it was a coworker and not a supervisor. The case may have gone differently for the specific plaintiff if it had been a manager. But what the court said is, yes, under the right facts and circumstances, one instance of saying the N-word could create a hostile work environment. But unfortunately, the court determined that in the specific facts for our plaintiff, that it wasn't sufficiently hostile, all the facts and circumstances to rise to the level of a violation of the law.
So this slide right here is just something that I show when I'm mostly doing the system impacted people. It's just prepare, always stand up for your rights, like I did. I felt like I stood up for my rights. I tell them always be prepared if you're in the job hunting mode, go to the Clean Slate program, get your record, draft some letters ahead of time, because if you do get denied if you do get your job taken back, those are some of the proof that you need. Make sure that you respond to the employer if they take the job back. Make sure that you respond, send support letters, know your rights, and check your records for error. Take action if you feel like you've been discriminated. File a charge with the Civil Rights Department. It's the Civil Rights Department Now, it used to be called Department of Fair Employment and Housing. However, that new link is in the book too. Also, I turned, like I said in the beginning, I turned to like an organization that kind of helped me until I can, I could stand on my own because I felt comfortable around people with my own lived experience. And you can always, if you can also call legal aid at work. If you feel like something that you've been discriminated and you don't know, call somebody and let them determine if it is and stuff, because that's what I did. This is where you can file this. This is the Civil Rights Department website, where it's really simple. You can go on the website and you could just, put the job application or the advertisement, the business name, and you can either file this anonymously or you can be notified. It's just real simple. I think, like you said, 3 or 4 clicks, and you can file a charge and stuff. I encourage anybody that feel like they've been discriminated against to always file a charge and let them look at it and determine.
Also, you can use that to report a per se on its face violation of the law. Del Taco's notice in most newspapers, or an employer's application, which still has the box question on it, and then the CRD. You can ask for, put your name so they can tell you the outcome, or you can do it anonymously so you can kind of move on, but so that they can notify the employer that they need to take that down, take it off, or whatever the situation is.
Doing, filing the Civil Rights Department, you can, different benefits. You can hold the employer accountable. You can get an explanation where they don't ghost you. A lot of employers ghost you. You may get the job back if you want the job back. You might get back pay or money, the compensation, where you maybe get money from when you should have been hired, when you should have started, up until the point where till now. You can change the practice of the company. That's a big one for me, change the practice of the company. Because if you can change the practice of the company, then more people can get jobs in that field. And you can, the company may, need training. We could go in and train them about the fair chance process. These are just a couple of the websites. I think they're in the book too, right? They're in the book.
That's
or
true.
You can also look them up. So the Civil Rights Department, I think you can find that on the website. Root and Rebound is an organization that does record cleaning. They have a legal clinic every Friday, and you can even do it over the phone. You can start the process over the phone, and they'll continue to tell you, but I know they do. East Bay Community Law Center also has a clean slate department where they do it. Most of the public defenders in different counties will do it. They just have to call, like I know Alameda and San Francisco public defender do it. And but the one thing about that is you have to call the county where your conviction is at. Yeah, okay. And all of a sudden, I put that up there all the time because I feel like they kind of saved me a little bit. And this is where I started being advocate from a movement, where my movement bug was bitten. And a lot of this, this is the San Francisco Public Library. A lot of the libraries have a lot of resources in them. So when I first came to San Francisco, when I first came to Island, I spent a lot of time at the library, just getting to know the resources up there. And and we work in 3 different, we work in discrimination, unemployment, and wage theft. But we don't have disability no more.
No.
Okay. So these are the 3, these are the 3 programs that we have. We also have a workers' right clinic, which the phone number is probably in the book. And this is our phone number, and we have offices up and down California. We have one in Fresno, East Palo Alto. So these are just some of the other offices that we have and phone numbers.
And our clinic, so people can call from their local areas and speak to someone.
Yeah. And that page is in the book too. And this is just our table of contents. It has a wealth of information in it. You know, if you have someone and you give them the website, I just advise you to go through that, and you can go through it too, because you might find, you know, someone might come and you can find out some information from this book too. 3 minutes. Oh, okay. And then this is just,
Summary, that's
Summary
kind
of
of
it.
where we started.
Yep. And that's it. I usually do a pop quiz. You guys want to do it?
We can do it in 2 minutes, let's go.
So, when can a potential employer ask about your criminal record? A, before giving someone the application. B, on an application, during an interview, or after offering a job? D. Yeah, D. We kind of do that because, make sure people are listening.
We were a success.
Okay. And I think that's the end of our,
We thank you so much for taking the time. I know you have a lot of choices about, you know, what you do for your in-service or your training, and we appreciate so much. Thank you.
Absolutely, and just want to share with everyone here and online that the PowerPoint will be shared in a follow-up email that I'll make sure to send to everyone who attended online and in person. Also, just want to take a brief moment to share that the Rising Scholars Program, if you're not already aware, has been doing work in offering courses in the West County Detention Center. For a little over a year now, we've offered 5 courses to different cohorts there. And there's also a campus support planning committee that we're always looking for more involvement in, and other ways that you can engage as faculty and staff with that program. So I'll also include in the follow-up email a link where you can let us know if there's ways that you would like to engage with Rising Scholars on any level, even if it's just making sure that future opportunities that we have like this to get professional development opportunities around this work, you can let us know that as well with that form that I'll send in the follow-up email. Also want to make sure you know, and I'll send it in the follow-up email as well, that we are hosting a Bay Area Systems Impacted Consortium convening, which that is pretty much all of the community college, UC, CSU practitioners, I think as far north as Santa Rosa and Solano, and I know San Mateo, San Francisco, that way, Alameda, Contra, Costa, all of the colleges and the practitioners that support students that are reentry students and systems impacted students is being hosted here at Contra Costa College on the 17th. So I'll make sure to include information in the email about how to attend that event. We've talked about Clean Slate a few times. There's definitely Clean Slate resources all the time, but on campus in spring we'll have another Clean Slate event for students, and definitely would love for you to get involved in any way that you feel comfortable and have capacity for. I want to thank Sandra and Sabrina for taking the time today to be able to put together this opportunity for us as well. So thank you so much for attending, and thank you so much for facilitating this opportunity for us.
Thank you. I really get a certificate.
Yes. I love certificates.
Thank you so much.
Thank you so much. Thank you. Okay, and here's a couple more books for you to share, put them in the library.
Oh, we